Ladies and gentlemen, it is my honor to introduce to this body the magnificent Judge and Justice of the Supreme Court, John Paul Stevens and Carol Lee. Please welcome them to the podium.
Is this all right?
While Justice Stevens and Carol get settled, let me formally introduce them. Justice Stevens, as you know, is one of the great icons of the American legal system. What you may not know is that he won a Bronze Star in World War II for his code-breaking efforts, which were enormously important. What you may not know is that while he went to the University of Chicago as an undergraduate, for some reason he went to Northwestern Law School, but has managed to have an okay career anyway. What I want to say about Justice Stevens, in part, are two things, because his career is so well known to this body and really to the world. When he was appointed, he was confirmed 98-0 by the United States Senate. After some point in looking at his career, President Ford praised him with these words, which I think, especially in today's atmosphere, are especially meaningful to me. In 2005, he said, "He is serving his nation well, with dignity, intellect, and without partisan political concerns." And I think that fact and the deep perception of the American people of that fact, Justice Stevens, were enormously important to them then and now. Let me tell you one personal thing, though, about Justice Stevens that I think reflects, in part, the impact that he has had on our world. A number of years ago, Justice Stevens came to Albuquerque to pay a little duplicate bridge in the summer. And he always said no one there ever really knew who he was. They just were there to criticize his bidding. And one of my partners then, who had been his clerk, Greg Huffaker, very nicely invited me and Barry to dinner with Justice Stevens, and we had a chat. And at the end of the chat, Justice Stevens said, "Greg, aren't you going to invite me to your firm so I can meet your partners?" Which, of course, we had all been afraid to impose on you to do. And he said, "Of course." And the next day, Justice Stevens made our lives so rich and gave those people clerking in Albuquerque, New Mexico, the ability to come back to their law schools and say, "So as Justice Stevens said to me at the firm." But what was really impressive to me was this. When Justice Stevens sat down with our clerks and, of course, everybody in our firm in a crowded room, after a few minutes, he said, "I want to ask you questions," because he wanted to make sure he understood some things from the perspectives of lawyers practicing in Albuquerque, New Mexico, and the impact that the court and the way they were thinking about had. And so he was our questioner for over an hour. And the fact that he wanted to know these things and listened was deeply meaningful to all of us, and I think reflective very much of his character and the reason he is in so many ways a great intellect. Our council member, Carol Lee, was Justice Stevens' clerk. She graduated from Yale not once but twice with honors, was a Marshall Scholar at Oxford, and as those in the body who have been here the last few years know, When she was elected to the council, I was very appreciative, but I now believe that she is one of our deeply beloved friend Dan Meltzer's greatest gift to the American Law Institute. And I think it wasn't Yale that trained her so well. I think it was Justice Stevens. So Carol and Justice Stevens will have a conversation about the law, and I appreciate both of them very much. Thank you.
Thank you.
Justice Stevens, it's wonderful to have you here today to talk with me before the ALI. To begin with, would you like to say a few words about Justice Scalia, who was your colleague on the court for 24 years and who sat next to you on the bench for much of that time?
Well, yes, Nino, of course, was a good friend, and all of you know as well as I do, he had a wonderful sense of humor and was a wonderful person. But with all the comments about Nino in the last few weeks, I don't think people have given enough attention to his skill as a writer. He really had a beautiful ability to express himself that I think very rarely does one find either in Judges or any other writing. He was an amazingly articulate person that I think we ought to emulate as often as we can. He's really very special skill.
Now that Justice Scalia is gone, we seem likely to have a prolonged period of having 8 justices on the Supreme Court, which may last through this term and much of the next term. Do you have any thoughts about the effects on the court of having only 8 justices for a prolonged period of time?
Well, of course, it's an unhappy situation. It happens from time to time, even without a prolonged period like this. But it's something the court adjusts to and will recover from in due course. But the sooner the better would be the answer, because the court is not operating effectively with only 8 people. Yeah.
Merrick Garland is a member of the ALI, and as you know, he's been nominated by the President to the Supreme Court. Do you have any comments on Judge Garland or his nomination?
Well, really nothing beyond what's pretty well known. He's a wonderful person and a wonderful judge, certainly well qualified for the position, and I think it's unfortunate that there has to be a delay in his receiving approval, because on the merits, he certainly is entitled to be approved for the court as soon as possible.
Thank you.
Yeah.
Now, I'd like to begin with legal methods, and to start with the question of bright line rules versus balancing tests. This is something that our institute grapples with frequently as we develop provisions of restatements or of model penal code and other documents. You and Justice Scalia took quite different approaches to bright line rules versus multi-factor approaches. To quote a Harvard Law Review article in 1992, if Justice Scalia leads the charge for rules on the current court, Justice Stevens is his most consistent standard-bearing antagonist. Justice Stevens has long favored sliding scale approaches over categorical rule-bound approaches. Sliding scale approaches over categorical rule-bound approaches. Do you agree with this generalization?
Well, I guess I do, but of course, you're talking about a general subject that has dozens and dozens of particular applications, and it always depends on the particular question that we're talking about to know exactly which school is a better approach to it. But I'm not exactly opposed to bright line rules. Sometimes they're very appropriate, but you can't generalize completely from those two categories of approach.
So basically you say that there is no bright line rule on your approach to this choice.
Right.
Do you trace any predisposition that you might have back to your legal education or law practice?
Well, yes. Of course, there's a famous statement that Nat Nathanson, the professor at common law, used to make in law school over and over again, to beware of glittering generalities. And that's something I often think about, that you can be more concerned with how nice the rule sounds without thinking exactly how it applies in case after case. Yeah.
Sometimes balancing tests are criticized for putting everything onto the table and not providing any guidance to the decision maker about how much weight to provide to any particular factor, so that there is a lot of discretion in the decision maker. How would you respond to that critique?
Well, I'm not sure I would. I think maybe there's some merit to the point, but of course, in any situation, you're always looking at the particulars involved in the problem you're confronting at the time, and how you deal with it is a matter of determines the particular issue that you're dealing with. So it's a little hard to generalize too broadly.
Turning to constitutional interpretation, you have taken the view that it is sometimes proper for the court to recognize rights that are not expressly mentioned in the text of the Constitution. And you've sometimes written that certain rights are protected by the term liberty in either the Due Process Clause of the Fifth Amendment or the 14th Amendment. In your view, how do you determine what rights rise to the level of being liberty protected by the Constitution?
Well, that's a good question. Of course, you have to take each case as it comes along, and the most important one in recent years has been the whole same-sex marriage question. And it does seem to me that the court correctly approached that issue by, instead of focusing on the equal protection arguments, to identify the right to choose a marital partner as an aspect of liberty. And I think that they're relying on that particular approach, I think, was eminently wise. I think it's a much more persuasive opinion than otherwise would have been. And I would have joined the opinion that Tony wrote. I thought it was an excellent opinion, and I think it was much stronger than it had been if it had used the other rationale.
So, taking that position on same-sex marriage, it seems that you don't consider that a right has to be deeply rooted in the history and tradition of the law in order to qualify for constitutional protection.
No, it's really interesting, because one of the byproducts of that decision is putting an end to the notion that everything had to be well recognized at the time of the framing and so forth and so on, because clearly that decision rejected the original intent approach to the constitutional interpretation, because I don't think anyone could claim that the founders originally intended that kind of a relationship to be constitutionally protected. So it's a very dramatic decision for that reason, and it has really a broader application.
So if you don't look or require history or tradition, what is it that you look to? Is it how important the claim is to the lives of individuals?
Well, of course, it's a combination of factors, and I don't think I could spell it out in any one sentence any more effectively than Justice Harlan did in one of his concurring opinions, for example. But a variety of factors affect the decision.
There was, the dissenters said that they didn't necessarily have any objection to same-sex marriage, but that it wasn't the role of the courts to decide, that it should be left to the democratic process, to the legislatures. How do you address that point?
The court has cases and controversies that have to be decided, and they can't just say, well, we'll let the legislature confront this somewhere along the line. They're real live controversies that need attention and decision, and they had to bite the bullet and make this decision at the time.
So now, turning to the interpretation of statutes, which we're often called upon to do as a member of the court, do you think that judges should approach this task differently from the way they interpret the Constitution? And if so, what are the differences?
Well, I don't have a neat category in which to place things, but you decide cases that come before you and you do the best you can with them. And certainly a lot of your analysis in statutory cases follows patterns that you follow in constitutional adjudication as well. But I don't think it's a question of putting one category of statutes and another category of constitution. You just try to decide the case as it comes before the court.
How much weight should the court place on legislative history in determining what the meaning is of a statute?
A lot. Well, it's true. Every case is different, of course, but you can learn a lot about a statute by studying the deliberations of Congress about the particular issue, what went before and what came later. I really think it's all part of the process, and it's an important part of the process to study the legislative history.
There have been some scholars who have counted the Supreme Court cases that used legislative history and didn't use legislative history. And they say that from the era before Justice Scalia came on the court, when I clerked for you, and the present day, or when you left the court, the use of legislative history in majority opinions of the court has noticeably gone down.
Oh, yeah.
Do you think that had an adverse effect on the quality of the results in interpreting statutes?
Well, I think a lot of it went down in the sense that it wasn't included in the opinions. And very often people look at the legislative history, and they will not write about the legislative history when they realize that Justice Scalia is going to disagree with the approach and so forth. And so, for example, I remember shortly after Sam Alito joined the court, he's a very careful examiner of the legislative history, and Nino tried to persuade him not to follow that course, and Sam took it, just decided on his own that it was very helpful to him, and he went ahead and put it in the opinions, and lots of times it affects the deliberations about what to say in opinion more than it actually affects the process of deciding the case. And that's true. The legislative history is an important part of the analysis, and I think everybody on the court, with possibly one exception, agrees with that, but didn't necessarily feature it as much in their opinions as I assume they will in the future, because they won't run into a big debate about using it. But it's quite obviously appropriate to use that as a source of reaching the right answer, and it will continue to be used, I'm sure.
Mm-hmm. Now, legal academics have sometimes called you a common law judge. The common law approach is something that's close to the heart of this institute. The founders thought of the role of the ALI as looking at legal issues as if they were aware of the entire body of jurisprudence and figuring out what that body of jurisprudence was, how it should be developed, or what trends, what directions it was going in. So do you think of yourself as having been a common law judge?
Well, well, not really, because I was administering statutes and doing everything else that federal judges do. But I certainly don't object to somebody making that reference. It's complimentary, I think, and but I'm a little unclear on what it would mean to accept the label or reject it.
Well, one point that is related to the idea that you're a common law judge is that you always placed great emphasis on understanding the facts of a case, the facts and the record. Do you think that those justices who perhaps placed less importance on the facts might have missed important things in the cases?
Well, no, it's every case is different and every judge is different, so I still think it's very important to understand the facts as thoroughly as we can. And in fact, I can remember when I was a Court of Appeals judge, when John Hastings was a senior judge at the time, and I first met and talked about the problem of writing opinions, and I still remember his saying, if you get when you write out the statement of facts yourself, if you get the statement of facts accurately and adequately, the rest of the opinion will write itself. And I think that actually is true in many cases. You spend a lot of attention to the facts, it pays off in your later completing the whole opinion.
So from time to time, you commented in an opinion you wrote for the court, whether it was a majority or a dissent, that you were voting to uphold a statute or policy that you didn't personally favor, or that you were voting to strike down something that you actually thought was a good idea. Why did you make this point when you did so in your opinions?
Well, that's an interesting question, and I thought a little bit about the subject since you mentioned it earlier. But the answer, I think, is that from time to time, it is helpful for judges to make it clear that they are acting as judges, not as policymakers. And if occasionally it's appropriate to say you happen to disagree with a policy judgment that the legislature has made, that illustrates the fact that your job is quite different from the job of the policymaker. And I think saying that once in a while in an opinion has a salutary effect and does some good.
It seems that there's a fair amount of public misunderstanding of whether the judges are favoring policy when they decide decisions, particularly in controversial areas. One thinks of, for example, the Kelo case about eminent domain. The court was portrayed in many circles as favoring taking away the houses of poor widows.
Yeah.
Do you think there's anything that can be done to lessen this kind of public misunderstanding?
No, I just think continuing to write the best opinions you can and explaining why the law requires the result, I think is just the answer. The process will explain itself over time.
Sometimes critics of the court say that it's engaging in, quote, unquote, legislating from the bench. Do you think that's a meaningful term? Do you think the court did this on occasion when you were on the bench? And if so, do you care to mention any cases in which you think this happened?
Well, have you got a couple hours? Well, the most dramatic example, I think, is the whole doctrine of sovereign immunity and the 11th Amendment jurisprudence that started out way back in Chisholm against Georgia and so forth. That's a manufactured part of the law that did not have to develop the way it did. And I really think it's quite unfortunate that the whole sovereign immunity concept became as important as it did over the years. And I don't think it had to become that important, and I think it's really an unfortunate development in the law.
Since you retired, Justice, you've published 2 books, 5 Chiefs and 6 Amendments, and now I understand that you're in the process of writing your memoirs. Could you tell us a little bit about what that's like?
Well, I've always enjoyed writing, I have to confess, and I've enjoyed the work, and I've enjoyed trying to continue in that activity, so that I'm not as productive as I wish I were, but yeah, I do have some fun trying.
How have you decided how much time and space to devote to different aspects of your career in the memoir?
How did I decide how much?
How long you're going to spend on your early life and on practice and Seventh Circuit and the Supreme Court?
Well, the early life was really very interesting. It brought back a lot of interesting memories. I enjoyed it very much, and I assume, but I'm at the stage now where I'm on the Supreme Court. I've gotten over the prior history, and it's a formidable task. An awful lot of stuff to cover, and I don't know exactly how to go about it. I'm confused at the moment about how best to continue working on it.
In your book, Six Amendments, you proposed 2 amendments that dealt with the political process, the electoral process. One of them was campaign finance regulation. The other was on political gerrymandering. If you had to choose between these 2 amendments, which of them do you think is the more important?
Gerrymandering, without any question at all. It seems to me that of course, the finance as a matter has developed over the years, going back to the Buckley case, but the gerrymandering is really something that could be very easily corrected if the court would confront the fact that it's no harder to identify a political gerrymander than it is a racial gerrymander. You can apply the same test and would make a huge difference in the operation of governments. The gerrymandering has had an actually adverse impact on the democratic process in electing members of the House of Representatives. There's just no doubt about it. It has adversely affected the electoral process over and over again in big areas of the country. It's just something that could be corrected, and the correction of it would make a huge difference in the way the country is governed. I think it's amazing to me that the problem, as simple as that one, has been not solved more promptly.
You made some efforts to persuade the court during your time as a justice. What do you think was the sticking point that kept the court from agreeing that political gerrymandering ought to be addressed?
You know, I really don't know, because I thought when Lewis Powell followed Karcher against Daggett in the Indiana case later, it really seemed to me that the right answer might follow from that, but it didn't. And I really do not understand what to me is a fairly simple problem, why it has been so long being recognized. And I really feel very deeply about that.
Now I'm going to ask you a question about oral arguments. This is not the question that you might expect that I'm asking, but it relates to the reduction in the number of cases that the court is hearing compared to the 1980s. When I clerked for you, there were more than 160 cases decided on the merits, and now it's about 70. But the question is not what is the right number, but if the court is now deciding fewer cases and there is room on the argument calendar for more argument time, do you think that the court should consider giving more argument time for individual cases?
Well, actually, they do every now and then.
Yeah.
They do make exceptions to cases and grant extra time. And I think that makes sense in particular cases, but I think it's appropriate to do it on a case-by-case basis, because an hour for a side is plenty in the normal case, it seems to me, and I don't think there's a need for a basic change in procedure.
I think I read that when you were a law clerk, there was more time for argument. Did you think it just was more than necessary?
I don't remember that, to tell you the truth. It seems to me it's about the same as it is now.
Mm-hmm. Now, on opinions and dissents, if you were advising a newly confirmed justice, would you recommend that it would be a good idea to follow your example and to write their own first drafts of opinions?
No, I think everybody has his or her own style and way of doing things, and I wouldn't want to tell a future judge how to go about that particular task. Everyone has his or her own special skills and ways of approaching it, and I think that's okay.
So how did you develop your own particular style on this?
Well, as I've indicated, I like to write, and I followed the example of Wiley Rutledge. He he would write out in a draft of opinion on a yellow pad in his own hand from page 1 all to the end. You get the completed draft done, and then Edna Lindgren would type it up, and it would be just one draft for the most of his work. Then we'd make edits and suggest footnotes and things like that, but it was his own project, and I really admired the way he put the opinion together. But I think everybody has his own style. Different lawyers have different styles, and you have to respect the individual's approach.
So as a law clerk to Justice Rutledge, did you actually ever have any visible impact on the decisions?
Not so much. He pretty well thought things through himself. He talked them out. We would talk about the cases ahead of the time, and but he had a practice. He would let his law clerks write the first draft on one opinion every year. I wrote the first draft in a case called Mandeville Island Farms against some. And my first draft essentially was it was a straightforward case. I thought a question of whether pricing agreement among purchasers of sugar violated the Sherman Act, and I thought it was pretty clear it did. And it took me about 5 or 6 pages to explain it, and I gave him the draft, and about a couple of weeks later, the draft came back with about 40 pages long. and my draft was sort of stuck in the middle. There's a paragraph that quoted from me. And actually, I thought that an older case, I forget the name, but had already been overruled. But he quite correctly thought that it should be overruled, so he wrote a long opinion overruling it. And oddly enough, time proved him right, because after I got on the court, that particular issue came up in an opinion that Justice Thomas and I had different points of view on, and Justice Thomas thought the old case was correctly decided, and he would overrule the case that Rutledge wrote that he had originally assigned to me. My good friend Clarence thinks that case should be overruled. So anyway, so I don't know. I've kind of got myself lost in this.
Oh, I think. Well, I recognize the phenomenon because when I clerked for you, I did not write opinions. Occasionally, there was half a sentence. And I would think very proudly, that is half a sentence that I helped with that shows up in the U.S. reports.
Yeah.
Also on opinions and dissents, when you were on the court, sometimes you dissented from an opinion that was the majority of the court, but then after that you accepted it as precedent and you would accept cases that applied it. But there were occasions when you didn't do that, when you kept on dissenting. You didn't say, okay, the court has decided it, we'll move on. And sovereign immunity is one of them. How is it that you decided when you would accept when you were defeated and when you would just keep on fighting?
Well, that's a good question, and I've thought a little bit about it. I think the answer primarily is that in statutory cases, I would accept the decision of the court even though I disagreed with it. And that happened on more than one occasion, because of course Congress is available to amend the statute later on. And so I think the court has a particular obligation to, in the interest of trying to keep the law stable and coherent, to follow statutory precedent and let Congress correct the changes. Whereas in the constitutional area, or the whole sovereign immunity debate back and forth, it seems to me, I did for a while try to follow the early 11th Amendment jurisprudence, but I found that you couldn't very well join an opinion that moved the law farther in the wrong direction, so that it was a different area, and I did dissent repeatedly in the sovereign immunity areas and things like that. Mm-hmm. Yeah.
So now I'd like to turn to a few substantive legal topics. Federalism. A majority of the Supreme Court has described states as sovereign in a very strong sense. They have constitutional rights against the power of the federal government. They have the right not to have state officials, quote unquote, commandeered by federal law. They have the right not to be sued in federal courts. You often have taken issue with that vision of the states. If states are not sovereign in that sense, do you have any vision of what their role is in the U.S. political system?
Well, I think the role is I don't think the name you put on it, I don't think is critical. It's okay to refer to them as sovereign, but the notion that their status makes their activities in the commercial world, for example, not subject to federal control is quite wrong. It seems to me that the Commerce Clause gives Congress the ultimate power when there's a dispute between states and in their proprietary. When they're acting as businesses, they should be regulated as businesses. And I think also in their regulations of the environment and things like that, their role is subject to the paramount control of Congress. I really think that's quite clear. But I've kind of lost what the question is right now.
I think the question is, what do you think is the role of states in the system?
Well, they have a role, but the Article 6 makes the federal power supreme, and when there's a conflict between state and federal power, the federal power should prevail. It's really as simple as that.
Mm-hmm. And in your sense, that goes back to the intent of what the Constitution was about.
Yes, yeah.
I remember that you quoted at length from Justice Rutledge.
The Declaration of Legal Faith.
Yes.
Yes.
And you've done that in subsequent cases as well. So
yes.
That view of the Constitution goes back to...
I think it's true, and it's interesting. He of course was best known as a civil libertarian. He gave importance to the First Amendment and so forth. But he recognized that the Commerce Clause was actually the product of the process that gave rise to the formation of the Constitution itself. And I think that particular quotation from his book that I used in EEOC against Wyoming,
yes.
was it? And other was dead right. Mm-hmm. And it's something that has not been appreciated as clearly as I think it should have been.
Now, let's talk a little bit about religion. Legal academics, including some perhaps in this room, have pointed out that when you were on the court, you generally took a position unfavorable to religion, both in Establishment Clause cases and in freedom of religion cases. So sometimes you have been described as hostile to religion. Then there are other academics who have sought to defend you from this characterization, including one of your former law clerks. He has written that you treat religion as a distinctive human good that ought to be protected from corruption by the state. And there's another academic who has described your position as respectful apprehension. In deciding Establishment Clause cases and religious freedom cases, can you tell us a little bit about your concept of how the court should deal with these claims of religion?
Well, I've thought about that a little bit since you shared that question with me before. And actually, The Establishment Clause was basically designed to protect Christian religions from discrimination, from protection within the Christian community. And it was not intended to protect Judaism or Mohammedanism or other crimes. And yet, I wrote the opinion in Wallace against Jaffrey, which makes that very simple point, that the framers' actual intent was much more limited than the principle that they adopted. They adopted a principle that's much more protective of religion than was the original intent of the people who drafted the Establishment Clause. And I think it's kind of interesting that that very simple point is often overlooked. And I do think that I wasn't hostile to religion or either way or not, but I did identify that example in Wallace against Jaffrey. Yeah.
Sentencing. This is a subject that is of interest and concern to ALI members. We're currently updating the sentencing provisions in the Model Penal Code. And over the years on the court, you had the occasion to think about federal law as it dealt with sentencing. Particularly interested in the question of whether a criminal punishment was so disproportionate to the crime that it was unconstitutional. That's a subject that you've addressed. Do you think that the intention of the framers is relevant to the way that the present-day court should think about proportionality?
Well, it's on the very basic issue as to whether the Eighth Amendment includes a proportionality component. Of course, Justice Scalia and I disagree on that, and he wrote more than one opinion saying that it was not part of the Eighth Amendment. And I think he was quite wrong. I think scholars generally have rejected his approach. But I do think it's important to recognize the fact that proportionality is a part of the constitutional protection in the Eighth Amendment. And I think cutting that out would be quite wrong.
Do you think that your view will continue to prevail?
Well, I think the law has pretty well settled on that point. And in Harmon against Michigan, Tony wrote an opinion that adopted that view.
Another sentencing question is back to the topic we talked about before, bright line rules versus balancing tests. How would you apply your thoughts about whether there should be bright line rules or all of the factors in the context of sentencing?
Whether there should be
bright line rules or more discretion and more...
Well, there's got to be discretion in the sentencing process. There's no doubt about that. But you also need both. You need both, yeah.
So how did that apply to your thoughts about the federal sentencing guidelines? The federal sentencing guidelines?
Well, I think it was quite right to make them advisory rather than mandatory, and that's, of course, a long story of its own. But and that's an area, and much of which Justice Scalia and I were in agreement on much of that debate.
And you wrote two important decisions of the court in Apprendi and Booker that dealt with the role of the jury versus the role of the judge. Could you comment on your concept of what the role should be of the jury and why?
Well, actually, in Apprendi and those cases, I thought it more important that the standard of proof beyond a reasonable doubt be an important part of the sentencing process, that you couldn't jump from one category to another based on a preponderance of the evidence standard. It was more that than the jury trial, I thought, of importance.
Now to the death penalty. Back in the 1960s, the ALI's Model Penal Code included a section on the death penalty, and some of the provisions in it were taken up by states in their post-Furman statutes. In 2009, after a memorable debate, the ALI withdrew that section of the Model Penal Code. And the reason it gave was the current intractable institutional and structural obstacles to ensuring a minimally adequate system for administering capital punishment. Similarly, your own views on the death penalty have evolved. In 1976, you were part of a plurality with Justices Stewart and Powell in creating a framework for the revival of the death penalty. And when I clerked for you in 82 to 83, you were still of the view that the death penalty properly managed was constitutional. And I vividly remember, and my co-clerk Jeff Lehman remembers as well, that you came back from a talk with Justice Brennan, and he said, "John, someday you will come to believe that the death penalty is unconstitutional." A quarter of a century later, it took a quarter of a century, in Bays versus Rees, you proved that Justice Brennan was right. And you wrote that the death penalty, as it had come to be administered, was unconstitutional. Can you tell us a little bit about how you made that voyage from one view to the other?
Well, it takes about 20 years of thinking to be summarized in one or two sentences, but there was a very definite process. We thought at the time, back in '76, that the death penalty could be confined and be administered pursuant to rather rigid procedures. And over the years, we were disappointed. I was disappointed to find that I thought the court liberalized the opportunities for imposing the death penalty rather than constraining it. And that there are a number of disappointing decisions over the years. But the thing that actually triggered my more dramatic conclusion in Bays was the realization that the death penalty was designed to be a form of retribution for very serious crimes. And the notion, as it's administered now, the death penalty cannot be administered in a way that causes any pain whatsoever on the defendant. And it's such a complete change from the original purpose of capital punishment to this put him to sleep on the table just as he's going into an operation. It seemed to me that the central purpose of the death penalty no longer exists because there is no more real retribution involved in the process. And it just seemed to me that the whole idea doesn't really make much sense anymore. Granted that back in ancient history, it could be to treat the defendants the way they had treated their victim and so forth, but you just can't do that anymore. And the whole thing is just, seems to me, totally anomalous now, and it really does not fit modern society. It doesn't do any tangible good. The society would be much better off not spending any money fiddling around with that particular form of punishment.
Do you think that... So do you think that in 50 years there will still be the death penalty in at least some of the states in this country?
I'm sorry,
do you think that it will be abolished altogether in, say, 50 years?
Yes, I think it's being done on a state-by-state basis, and I really think there's much less enthusiasm for preserving it than there was 25, 30 years ago. I think it's on its way out.
Now, equal protection. One of your more famous passages was from Craig v. Boren, a case decided in 1976 about the drinking age for 3.2% beer, in which males and females were treated differently. You wrote, "There is only one equal protection clause. It requires every state to govern impartially." What did you mean by one equal protection clause?
Well, of course, that was in the context that at the time there was a three-tiered approach to equal protection, where you put the case in the right category, and then the result would follow. It seemed to me that it made much more sense just to analyze the reasons for the classification, the burden on the disfavored class, and rather than trying to pigeonhole the three different categories.
Do you think that this is a question of description or a question of outcome? Do you think that if your approach were adopted, equal protection cases would come out differently, or is it just a question of a more, in your view, accurate way of describing the process of decision?
Well, I think it's a little both. I think there was one case involving discrimination against the mentally retarded that I think may have come out differently. I don't remember the name of the case right now, but Byron White wrote it, that just approaching the one approach rather than three-tiered approach did help solve the case.
And I got a note from Roberta that we don't have a huge amount of time left. So let me turn to campaign finance, because this is a question that I would like to ask. You dissented quite forcefully in the Citizens United case, which struck down the federal ban on independent expenditures by corporations and labor unions. Do you think that your view about political corruption and influence was affected by the fact that you came from Chicago?
I don't know. Although I will say, Bill Rehnquist and I used to kid one another from time to time. He came from Milwaukee before he lived in Arizona, you know, and he that was a law and order state, and Illinois was not. And we used to say that you had a constitutional right to jaywalk in the Loop in Chicago, whereas in Milwaukee you'd go to jail for jaywalking. But there was a difference in the culture, that's true.
So you have written in 6 amendments that the Constitution should be amended if necessary, if the court doesn't see the error of its ways, and that the Congress should be permitted to make reasonable limitations on campaign expenditures. Do you think that legislatures can be trusted to enact reasonable limitations on expenditures, or would they find ways to adopt limitations that actually favor the reelection of incumbents?
Well, you know, every legislator is different. You can't be 100% sure, but I think they could handle the problem. Yeah.
Roberta, do we have any more time, or is this it? One more question. Okay, one more question. First Amendment. Sometimes it's difficult to pigeonhole your view of freedom of speech under the First Amendment. In some of your better-known dissenting opinions, such as Citizens United or the flag-burning case, you disagreed with the court's decision to strike down a statute on First Amendment grounds. Do you recall any instances or categories of instances where your views were more protective of freedom of speech under the First Amendment than the majority of the court?
Well, yes, actually, it goes back to my years on the Court of Appeals. I really think that I wrote the first appellate court opinion condemning the patronage system, and I relied on the First Amendment analysis in that case. And at the time, that was considered a wildly incorrect approach. But I think over the years, the patronage system has not survived, and that my opinion did survive.
Well, thank you very much. Thank you so much, Justice.
Thank you.